Hello, thank you for joining us. I'm Jennifer Ryan, a lawyer with the Beauchamps corporate team. We are all learning to adapt and implement new practices in response to the challenges posed by COVID-19. The crisis has had a profound effect across all areas of businesses, and including for many businesses, the ability to perform their contractual obligations. What we are seeing is that for many, they were seeking more time to adjust their practices and assess what they can deliver. And what's happening is that many want to maintain the existing relationships, and they're looking for alternative options rather than terminating the agreement and having to go renegotiate the entire terms. My colleague Eddie Evans is going to step you through some of the insights on how to manage contractual obligations when they're not being met and key takeaways. Over to you, Eddie.
Thank you very much. And firstly to say, in Beauchamps, we're very conscious that in these difficult times, it's, firstly we want to say a big thank you and a shout out to all those in the front line, the health sector, etc., doing a great job in this crisis. And we thought that in business terms, business also needs to lead and work through the crisis and find solutions in this crisis to dealing with what's currently in front of us. Essentially, the COVID-19 pandemic has created a lot of uncertainty for business, a lot of difficulty in terms of performance of contracts. And we're looking at that performance issue now and just talk you through what we are suggesting, our recommendations on how to deal with some of those issues. Now, it affects a range of contracts. It affects supply contracts, it affects distribution contracts, it affects agency contracts, and a range of business contracts. And I'm going to talk about those now. It's across all the industries, as we know. I'm not going to talk about employment law contracts. I'm not going to talk about property contracts. We'll get back those in another webcast. But for now, I'm just concentrating on the commercial contracts. So what I'd like to tell you about is how businesses can best manage and deal with those performance issues. Performance issues come in different sizes and different shapes. I think the first thing we're saying to people is you need to assess what the performance problems are. What are your particular problems performing at the moment, or what are the particular problems your suppliers, etc., are having in performing? That may be something that is short-term. It may be something that in a multi-year contract isn't going to affect you except for a short period of time. The question then is, when you analyze firstly your performance issues, what's the next step in legal terms in terms of trying to address those? So typically contracts will have a range of remedies about performance remedies, breach remedies, etc. And will also deal with things like force majeure and frustration. Force majeure is a concept that allows people to say, hey, I can't perform temporarily, and that's okay because of this intervening event, i.e. the pandemic. It gives forgiveness, temporary forgiveness for non-performance. But it doesn't create a real solution, it just creates a bit of a pause. In that pause period, and if you don't have force majeure, we're saying in that pause period, you need to also look at the legal doctrine of frustration. That again allows people to say the same thing, hey, I can't perform, and what do I do next? What we're saying people need to do next is then assess their actual individual contract and look at what solutions they can put in place in a temporary way. Because while there will be dispute resolution mechanisms, mediation, maybe arbitration, even litigation, that's not really a practical answer at the moment. So what we're saying, the practical answer is look at your contract and assess what commercial solutions in a short term you can put in place by way of a contract amendment. So when you look at your contract, you'll be able to change and put in place some temporary forgiveness, some temporary extension, or some temporary change to the commercial terms. A lot of good commercial solutions out there, stretching out payments, extending the time period, streaming payments, looking at compensation mechanisms for, well, if I can't perform this way, can I perform a different way? Can I give you different goods? Can I give you a slower service, or can I give you a substituted service? All these things means that the performance issue is quite complex in the sense of how you assess it case by case. And what we're saying is you need to do that. You need to assess it case by case. When you get to the solution set, that solution set, be it stretching it out, be it taking more time, that can be easily captured in an amendment agreement, a variation agreement. What that allows business to do is get a bit of certainty that there's not going to be a nuclear option exercise. Contract isn't going to terminate. We can work our way through this and capture and document in your contract exactly what that solution is. That'll also allow you to look at what probably unthought of, but now something we need to think of, compensation measures are. So if I haven't been able to perform or haven't got supply for a particular period, what are the compensation metrics around that? If I've only performed half my contract, or only get half my fee, or what is the metric to compensate someone for that? In a very similar way, SLAs, service level agreements in IT contracts will also have those sort of performance metrics, KPIs, of what happens when it goes wrong, what is the measure of compensation. So those special arrangements will help you future-proof your contract when you change it and put in place an amendment agreement. So what we're really saying is you've got to do 5 things, and our 5 takeaways for this are really: 1, identify and assess what are the performance issues of your contract. Secondly, assess the actual contract itself. What remedies does it give you, and or what solutions does it provide? You probably won't find a really good answer in that. So the third point is engage with your contract counterparty and try and come up with commercial solutions. And then fourthly, document those solutions. Put them in an amendment agreement, put it in place, give certainty. And the last point, the 5th point, is that will help you future-proof and agree what the compensation mechanisms might be going forward if it continues, if there's an extension of this period. And that's really what we're saying to people. So in summary, that's it. I'd like to thank you for your time in looking at this. Thank you, Jennifer. And in the words of the great Dave Allen, may your God go with you. Thank you.
Thanks, Eddie. They found it very useful, and I hope everyone will find those kind of 5 takeaways useful when they're advising their clients and looking at their business needs. So thank you. Thanks for joining. If you have any questions, please contact Eddie or myself or anyone on the corporate team. We'd be happy to discuss.